I am troubled by the use of the phrase official copyright in the question. I think you understand that copyright comes into existence at the moment of creation, when a work is fixed in a tangible medium of expression from which it can be perceived with the aid of a machine or a device or with the naked eye. You have a copyright instantaneously, automatically, under federal law. Copyright is not a verb, so when people talk about copyrighting something, I become confused because I don't know what they're talking about. The question is underlying what you asked is whether a registration for a copyright is necessary, or when it should be obtained. So let's distinguish, very important, those two things. A copyright comes into existence at the moment of creation under federal law. When you write something down, you have a copyright. To file a lawsuit and for certain other benefits, you need to register that copyright with the Copyright Office in Washington. It's a mere formality. It is not a prerequisite to owning a copyright. Once that copyright registration is filed, it gives you certain statutory benefits. They are, first, access to the courthouse. You can file a lawsuit. I say it's a ticket to the courthouse when you have your registration, if the registration is before the infringement. It also allows you to recover statutory damages, which is an amount of money the judge can set in his or her discretion to punish someone who's a willful infringer or to let it to go easy on someone who's an innocent infringer. And most importantly, it gets you attorney's fees. Near and dear to my heart, you can't recover your attorney's fees, which can run $1 million in a lawsuit, unless you've registered the copyright before the infringement. So registering copyright is a great idea. There is no reason not to do it. It can be done all electronically online. The registration fee is $55 for a single work. It is one of the most economical ways of protecting intellectual property there is in the U.S. I have heard people purporting to be knowledgeable about publishing say, oh, a publisher might object if a work was copyrighted before you submit it to the publisher. Complete idiotic, wrong. Anyone who says that is misinformed and should not be listened to. So there's no reason not to file a registration on a copyright. But I represent photographers, for example, where there's 3,000, 4,000 images a day. Very burdensome to register copyrights in all of those. Which do you register? When do you register? My rule of thumb is to register before publication. And I don't mean a formal publication where the book is bound and thousands of copies are printed. Distribution to the public. Before you take your manuscript out of the drawer and come to a writer's conference and start handing it around to collaborators and publishers and agents and others, have a registration with the Copyright Office in place. Just a good protection and lets you know what to register and what not to register. Okay.